KFSR 90.7 FM, and CMAC, Comcast 93 and AT&T 99 present the Central Valley Ledger, formerly San Joaquin Spotlight. Tune in to 90.7 FM or Comcast 93 and AT&T 99. I'm your host, Sevak Tatiosian. Welcome to the Central Valley Ledger, formerly San Joaquin Spotlight. Today we're going to be talking about something interesting. It's been in the media a lot the past several years. It's the lawsuit abuse, and we'll let our expert tell us a little bit about what's going on. Rochelle Golden, attorney, thank you for joining us.
Thank you so much for having me.
So before we talk about the area of law that you practice, let's talk about yourself a little bit. So, you're in Fresno. We're in downtown Fresno now. Have you always been in Fresno?
I grew up in Fresno, yep. I was a boomerang, so I went to Bullard, graduated, and then went to San Diego for as long as I possibly could. And then decided to come back here for law school, and now I'm here. I've been here since 2008 consistently.
What got you to go to law school? And, like some people like me, got a law degree, but we're not practicing, and there's a test called the bar that was a little challenging. But why'd you decide to become a lawyer?
Well, actually, so I was in a snowboarding accident when I was 15. So I use a manual wheelchair full time, and that actually kind of propelled me into interior design, doing accessibility design and things like that. Once I got into college at San Diego State, I was an art major and didn't want to pick out faucets for the rest of my life. So there were some situations that happened on campus regarding accessibility, and realized, okay, maybe I should do law and advocacy and really try to work with people to get things more accessible. And so that changed from art to ultimately English. And then I went to law school after I graduated.
One started with art.
I did,
grew into English, and then law school.
Yeah.
Interesting transition there.
Yeah. So it was a long road, but I finally made it.
Any advice for up-and-coming lawyers or people who want to become lawyers?
Well, my boss now actually told me when I was an undergrad to take some time off after undergrad and work and make sure that you really want to go to law school. And thankfully I heeded that advice and was actually in radio, and really did not want to do that forever. So then I went back to law school, and I was motivated to finish it. If I hadn't have taken that time to really think about it, I probably would have pushed through it, or would have failed out and not gone back or something like that. So
you're a practicing lawyer now, and one of the reasons why we wanted you on the show is because we hear all the time about these small businesses and these business owners who get a visitor. The visitor uses the restroom or tries to maneuver in the building, or somehow the visitor then talks to an attorney because the building is not compliant with ADA standards. So tell us, I gave you in like a 50 seconds something you could talk about for hours.
Sure.
But so tell us what this is all about.
Well, when you say visitor, most of the time there's no visit. Let's be very clear.
And I learned something. Something. So there is no visitor mode.
Sometimes there is, but oftentimes they're not. They've been coined drive-by lawsuits, and it's poignant because it truly is somebody driving by in their car. They see maybe parking that's out of compliance. They're scared to get out of their car. And so instead of actually going inside the business, then they file a lawsuit. Those are really maddening for business owners because they will tell you, nobody ever came in, I never saw anybody. Of course, we would have helped somebody if we saw them or needed help, needed assistance, we would have done that. So that's kind of one category. And then the other category is exactly what you described. Somebody actually does go inside the business and then needs to use the restroom and can't. And so whether it be because the toilet paper dispenser is out of alignment, not in the right spot, or there's no grab bars in the bathrooms, or there's not enough accessible seating inside of a restaurant. So there's a whole host of issues that people allegedly encounter, and then they will file a lawsuit.
And the basis for the lawsuit is ADA. Can you tell us a little bit about that?
Yeah, so the Americans with Disabilities Act was enacted in 1990, and it took effect in 1993. And it was a really great body of law that basically says that people with disabilities are free to use and enjoy any place of public accommodation. That's hotels, restaurants, movie theaters, any place that's open to the public.
And I hate to interrupt you, but that makes sense. So, I mean, that's a good thing.
It is a good thing.
So continue, please.
And it's a good thing because I, as somebody that uses a wheelchair, need that. It's something that's necessary and it's valuable and it's appropriate to have that type of legislation. But what's happening is that California state law has become so stringent and has made it so profitable for plaintiffs to bring these types of lawsuits, because under the federal ADA, there's no money that you can get, no monetary damages that you can get. You can only get injunctive relief, which means you sue somebody to make them do something, change the restroom, put in parking stalls, change your signage, whatever it may be. Well, in California, you get $4,000 per visit to the property.
Oh, wow.
Plus your attorney's fees and costs.
Oh, wow.
So they take their federal ADA claims and then they attach their state law California claims to them, and then they get injunctive relief and money.
Interesting.
So that's why this has become such a popular area of law.
So what upsets some business owners that I've talked to is that there's no real, like what happens is the lawsuit gets filed and then they say, I'm happy to make the changes, you know, they just need to give me a certain amount of time, but that doesn't happen necessarily. They're hit with the fine. And you can correct me if I'm wrong on this.
Well, in California, you do have a requirement as a plaintiff to serve a demand notice, which is, I've been to your property on this date, I encountered these barriers, you have 30, 60, 90 days to fix them. In federal law, that doesn't exist.
Okay.
So instead of bringing these cases in state court, they're bringing them in federal court so they don't have to jump through all of these hoops. And so businesses are getting literally slapped in the face with the lawsuit and they had no idea. The problem is that since this law is so old, legislatures, lawyers, and judges alike are losing patience with people that aren't aware of this, and don't like the "I didn't know" defense, because it's been 25 years.
Well, and so walk us through the process. So the drive-by or the visitor then talks to an attorney, and I understand that there's a few attorneys that are going around doing this more than others. So
Correct.
they go talk to the attorney, and then what's next in the process?
Well, let's be very clear. They don't go talk to the attorney. The attorney uses specific plaintiffs for different areas. So you have, here in the Valley, you've had Hanford, their entire business district got hit within a couple of days' time. You've Orange Cove, it's happened to them as well. Lemoore, it has happened. So literally you have one person going to an entire small area, Avenal it's happened to, and suing the whole business district.
Wow.
In 1 or 2 days. So what's happening is that most of the lawsuits are brought by two firms in the state of California. One's in LA and one is up in San Jose. And then you have 14 plaintiffs that are serial plaintiffs that are bringing all of these lawsuits.
Well, and who's getting, it sounds like a get-rich-fast scheme. I mean,
It's very profitable.
the law is important. It's important that the law be followed, but if it's 14 plaintiffs that are going around and the same attorneys that are suing, so are they splitting? Do you know who's making the big profit here?
The attorney is. I don't know what the fee agreements are between the plaintiff and the attorney. I have no clue. I've not done any plaintiff's work myself, so I've never entered into that type of an agreement. But I will say this, whenever you are up against a settlement offer with one of these few firms that do this, it is well over $4,000 that they want. So the plaintiff will presumably get the $4,000, and then the attorney will get whatever their attorney's fees and costs are.
So once that happens, though, is the business off the hook? So let's say that I'm the small business owner, and I get hit with one of these lawsuits, and I say, okay, you know what? It's going to take me longer than the 90 days to fix these improvements, and I'm going to take 6 months, but I'll settle with you. So the settlement happens, and then is there worry that what happens then after for the business owner who settles?
Okay, well, the business owner who settles with that particular plaintiff is good to go if they've signed a settlement agreement that says I'm releasing all known and unknown claims. So basically that particular person can't come back and sue the business again. However, in the meantime, there can be other plaintiffs that come through and sue the same business for the same thing.
So then the business, possibly the business will have 3 or 4 different lawsuits coming up on them. You have talked to business owners. What do they say about this?
They're upset. And rightfully so. They're really, really upset. They ask any business owner, and somebody that, as I said, uses a wheelchair, I know this to be true. If you need help, they will help you. But they don't want to, A, offend you by helping you when you don't need it. But B, also they're blindsided because they had no idea that this law existed. And what's happening is that these lawsuits are targeting small businesses who primarily do not speak English. So you have people that are coming here and setting up businesses or have been here and are just, first generation English speakers or whatever the situation may be, and they have no idea what they're up against. And so it's really unfortunate for the low income minority demographics because that's who's getting hit the hardest.
I mean, I imagine that small businesses are being crushed by these kind of lawsuits, but are you aware of anybody that had to go out of business? I know that in the paper there were some write-ups about businesses that said, you know what, I can't go on anymore. So tell us a little bit about the most difficult stories that you've heard regarding this.
It's really sad because you have these small farming communities that are struggling as it is. Obviously, we're in a water crisis, so there's been a lot of hardship with farm workers. And so you have these mom and pop shops that serve this type of community that are barely making it. And then you get this plaintiff that comes by and sues the entire town in one day, and literally businesses will close. And not only does it affect the business, it affects the city because their tax base is completely just ripped out from underneath them. So it's really harmful to not only the state of California, but also just to your community. It depletes enthusiasm, it depletes the willingness to change, and it also starts to put in the discriminatory animus inside of someone's thought process because now they've been sued, and why would they want to help anybody? I've personally now have experienced discrimination. People look at me when I come into a restaurant, and I've never experienced that in the 17 years that I've been in a wheelchair. This is the first time this is happening.
And I'm glad you're going this direction because I wanted to ask you on that. So the negative of this is not only to the business owner, but there's the discriminatory effect of it.
Absolutely.
So what advice would you give business owners that are listening to the program now that want to make sure that they don't get hit? Because I imagine there are some business owners that have no idea that this is going on until they get the lawsuit.
Right. There are certain things that you can do. There's a program in California called the Certified Access Specialist Program, and it is a test that you sit for, and it's engineers, architects, general contractors, anybody with a certified design engineering background, construction background. They sit for this exam and they literally memorize the building code, the California building code. When you hire somebody, a CASP, to come to your property and do an audit of your property, they're only looking for ADA violations. And by ADA, I'm saying as well California building code violations. When you do that, there are certain procedural advantages that happen if you are a small business and you're sued. You immediately get a stay of your case in state court, and you get a reduction of your statutory penalties from $4,000 to $2,000. That's significant for a lot of these business owners. In federal court, the law doesn't technically recognize what a CASP is, but your threshold to meet is doing what's readily achievable in federal court. Well, you can't do what's readily achievable unless you know what your liability and exposure is. So hiring a CASP will also benefit you in federal court because then you have a defense saying, I've done what's readily achievable. I now know what my violations are. I'm working a schedule. I'm doing what I can within my budget to make sure that these violations are corrected. So it's a really great program.
It sounds like it. How do people change? So it's state law tacked on to federal law, but how do people change that? And do you foresee that happening? I mean, this is an important law. I mean, I know we're talking about the other side and the side that they're abusing this law, but this is an important law. So do you foresee that any changes to this law happening soon? And could we make changes as citizens?
Yes, there are changes that are happening actually. we just had two new laws passed in October, and one is a small business loan program for specifically small businesses to make ADA retrofits to your business. They haven't set up the protocol of how you would actually apply for this type of loan yet. Hopefully, within the next 30 to 60 days, that procedure will be coming through the legislature so people can actually start applying for this. It's $10 million per year, and it's done through the California Pollution Control. So it's going to be replenished every single year. So that's a great asset for small businesses that don't have the money to do a bathroom remodel or what have you. And there's also another, well, basically it's a new definition of litigant. It's called a high frequency litigant that was just added to the civil code. And it basically says that if you are a person that has brought 10 or more lawsuits in 1 year of the ADA nature, or you're an attorney who has 10 or more lawsuits in 1 year, then you need to report your complaints, demand letters, settlement, judgment to the state bar. So the state bar is now looking at these attorneys.
Very interesting angle. Very interesting angle.
Yeah, they're now looking at these attorneys and plaintiffs of, okay, who are you? What's happening? How much money and how many suits are you really filing? So in the California arena, there has been some change. It's been slow. We can do a lot more. But I would say the biggest thing is to write your congressman, write your assembly members, reach out to your politicians who are serving you, because your politicians are starting to get upset as well.
Well, and those who are advocates of this law, I would think that they also are getting upset that this law is being abused. I mean, would you say, like, the people who are advocating for, ADA laws, I would imagine that they're getting upset if someone is going around, getting rich off this law.
I haven't seen that.
Okay. And what are the, I don't know if you've ever talked to any of the plaintiffs, but maybe you've talked to the attorneys. Have you asked them, like, hey, give us a break here or something? I mean, what is their driving force? Is it money making or change?
Money.
And it's sad that they're doing that.
It is sad because a lot of times they don't put in your settlement agreement, there won't be any mention of any structural or ADA change. I shouldn't say structural, but any ADA change. They don't care whether you fix the property or not. Sometimes they will put in, okay, you have 6 months to fix the problem. They'll never come back and check on you. So they don't care that that the changes are actually getting made. They just want their money and they want to go on to the next place. So it's really, it's really frustrating. Really frustrating. So
this is your area of law that you practice? I mean, is this, I'm sure, do you do other areas of law? Or this is, so in this, if a business owner contacts you, what do you do? So let's say I'm the business owner. I have this letter saying that XYZ firm is suing me. I bring it to you, then what?
What I do is the first thing I do is I will Google Earth their property. And the reason why is because I want to make sure that what they're getting sued for hasn't actually already been changed, because that has happened.
Oh, interesting.
So they'll get sued. Somebody will get sued for parking lot violations, and then I will talk to the person, and they'll say, "Wait a minute, I fixed this 6 months ago." Okay, well, it's because they never actually visited your property at all. So I will always Google Earth the business. Then the second thing I will ask is, have you had a CASP report done? And most of the time it's no. And if it's no, that's the first thing that I do, is I will hire somebody to go out, and because I need to know what my client's exposure is. And I need to know how significant and how expensive it is in order to make these changes, so then I can start figuring out how I want to approach the case.
Have these ever gone, in your experience, to the actual trial court? I mean, where you get a jury and you put on testimony, or in your experience, has this always been settled?
I have not taken any to trial. I have not taken any to trial. However, they are happening. Judges are getting mad because they're bogging down the court calendars. Judges are getting upset, and attorneys are getting upset, and people are starting to grasp, okay, there are ways to actually defend these. I think a couple of years ago it was just settle, settle, settle as quickly as possible, and sometimes that's very appropriate. But there are other times where it is not appropriate. And so attorneys that do this have a specialty in this, or not a specialty, but have an emphasis in this area of law, they are starting to fight back and starting to take these through trial. And so we are starting to see cases come down a lot more frequently, which is really great, because then it gives more guidance on how these how these laws are actually being interpreted.
Talk about 10 years from now. Where do you see this area? I mean, do you envision that these lawsuits are going to continue and people are still going to sue for these things, or do you see some more changes happening in the current law to accommodate some of these small businesses?
I would say in the next 10 years they'll still be here, because until we take out the statutory penalty of $4,000, and until we take out, you can get your attorney's fees and costs out of the statutes, then it will always be advantageous for the plaintiff to do it.
And the interesting part is the attorney fees. So if an attorney writes a letter, I mean, you know, I would be curious to see the billing on these things from these attorneys, because you know, if I'm sitting up north in a law office up north, and I'm just going to send a letter to a business, you know, it'd be interesting to see what I'm charging for that letter. I'm sure you've seen some things. What's the attorney fee amount on these things?
It depends. It depends on how far it goes. I've had attorney's fees that are minimal, $500. But I've also had some attorney's fees that are in the thousands. It just depends on how you attack it and how quickly you can get your client out of the case.
For people that are upset about these lawsuits and that want to go the discriminatory route or get misconceptions, what advice would you give them, or what do you have to tell them? I hate to put you on the spot on that one.
No. What do I have to tell business owners? Is that what you're asking?
What do you have to tell business owners that now have some misconceptions about this law and, you know, are devastated by the law?
I actually had a conversation with somebody today about that, and it is important because I need it. I, as a wheelchair, need it. When my grandmother was living with us, she needed it. She used a walker and then ultimately a wheelchair. A disability is something that can happen to anybody at any time. I was born able-bodied. I suffered an accident. My parents' world changed. My brother's world changed as soon as that happened. And you start to see the beautiful thought behind the ADA. It is so important. It is a necessary part of how somebody with a disability functions. But there has to be a balance. And so in order to find the appropriate balance for a business owner, what they need to do is they need to do their part. You can't just sit on your hands and say, I didn't know, because the law has no sympathy for you. However, if you do your part, you can beat it and you can win, but you have to do something. So there needs to be this balance, because literally it could happen to anybody at any time. So it's a really important body of law.
So we've spent quite a bit of time talking about the ADA area which you practice. What are some of the other areas that you practice?
So I work for Overstreet and Associates, and we represent city governments. We are contracted counsel through the city attorney's office, so we represent the county of Fresno, the city of Fresno, Reedley, Kings, all over. And we do tort defense. So anytime there's an incident that happens on public property where somebody gets hurt, we represent the government entity.
Interesting. So of all the areas that you practice, do you have a favorite, or is that the question, you know, pick your favorite child type of question?
No, I love the ADA law the best. And the reason why is because obviously it's close to my heart. My father's an architect, and so I grew up in the design world my whole life. He's actually a CASP. And so it's really fun to work with him and to have this kind of family dynamic. I don't use him exclusively, but I have a real passion for seeing change, and I have a real passion for seeing the mindset of business owners change, because when you first approach them, it's, this is so expensive, I don't know how I'm going to do this, what do you want, this is insane. Well, it doesn't have to be expensive, and let's take it one step at a time. And so I love that relationship that I get to build doing something positive and affecting change and implementing the ADA through a proactive standpoint, because I also do proactive consulting, which is my favorite part, because it takes the blinders off and allows people to be empowered to make changes for themselves on their own time frame, and also to reduce their risk of getting sued.
So if I'm planning on opening a business, what would you tell me?
Hire a CASP. Seriously, hire a CASP. Hire an attorney who knows what they're doing, who then hires the CASP, so it's all done confidentially, attorney work product, attorney client privilege. And then that way, if they were to get sued, then anything that's not relevant to the particular lawsuit gets to be kept out, so that attorney doesn't get to bring another plaintiff and another plaintiff and another plaintiff, because then they'd have your whole CASP report. Well, if you open up a business and you hire an attorney who hires a CASP, then it's all done confidentially, and you get to keep some of that back.
So we're running out of time this week on the program. We've talked about a lot of things, but how can people get in touch with you, and are you willing to take phone calls from our audience members?
Sure, I'm willing to take phone calls. I'm Overstreet and Associates, and I can be reached at 559-221-2771. And you can email me as well at rtg@oa-law.net.
And so, lastly, running out of time, but so this area is an area of law that we're going to see. Do you think we're going to see more lawsuits or not?
I do. I think we're going to see more lawsuits until we can effect some really stern and hard-nosed change.
Rochelle, thank you so much for coming on the program this week.
Thank you so much. It's been a pleasure.
That's all for this edition of San Joaquin Spotlight. To the volunteer crew, actually, I take that back. Formerly San Joaquin Spotlight, and we did a name change recently, and I've caught myself doing that several times. The volunteer crew is in the studio. They're probably laughing at me right now as we speak. This is the Central Valley Ledger, formerly San Joaquin Spotlight. I'm your host, Sevak Tatiosian. Today we had Rochelle Golden talking about the ADA lawsuits that we've heard of in the media. Thank you again for coming.
Thank you so much for having me.
To the audience members listening to this broadcast on 90.7 FM KFSR Fresno, thank you for tuning in. Thank you also to those viewing this on Comcast 93 and AT&T 99. Hope you enjoyed the show. Hope it was educational for you this week. Tune in next week to a new edition.